Good morning. I'm Dean Wallraff. I'm a lawyer in California and executive director of Cool World Institute, which helps facilitate climate change litigation around the world. We're here on Earth Day 2020, the 50th anniversary of the original Earth Day that occurred in 1970. And this is a teach-in on environmental law for environmental activists, not lawyers. So the focus is on tools that you as an activist can use to fight climate change. The other presentations from today, there are 6 of them altogether. Actually, there are 10 of them altogether, but we couldn't put up one of them because of copyright issues. They're all posted, the videos and the PowerPoints are posted at the Cool World Institute website, which is coolworld.institute. And if you go to that site, then you can look for a link to the Earth Law teach-in that has a list of the presentations and links to the videos and PowerPoints. So if you want to see any of the other presentations like this, just go there. What I'm going to talk about today is the environmental impact assessment process. So let me get my screen sharing set up here. If I can do it. Okay. Okay, so this is our topic. We're going to be talking about using the EIA process to fight for the environment. Cool World Institute first is a project of advocates for the environment. It's a law firm, which is a law firm that I run in Los Angeles. Cool World Institute recognizes that litigation is a really important tool for lawyers to use. It's something, I call it a superpower because it's something lawyers can do, but not everybody can do. And our mission at Cool World Institute is to facilitate climate change internationally by cross-fertilizing between countries, bringing together climate litigators to share ideas, researching potential legal claims, and organizing certain types of climate litigation. As you can see from Michael Gerard's presentation today, the US has the lion's share, has done the lion's share of litigation against climate change, and exporting that to other countries, showing other people how to use some of those claims, legal claims that have worked well in the US and have been effective, to use those in other countries is one of our goals. So we've been litigating against climate disruption in Los Angeles for almost 10 years now. And I'm the executive director of Cool World Institute and Advocates for the Environment. Here's an agenda for today's talk. This is what we're going to discuss. First off, we have a somewhat international perspective because that's the perspective we took at Cool World Institute. This talk I'm giving on environmental impact assessments is based on a panel discussion we had at Climate Law and Governance Day in Madrid in December 2019. That was an all-day event held at the Madrid Law School in connection with COP25, the follow-on to the Paris talks. So there's one of those COPs every year. The next one's in Edinburgh. So I'll give you a quick, just a little bit about our climate litigation toolkit, the idea there, and then I'm going to talk about the environmental impact assessment process. It's what I think of as the Swiss Army knife for environmental activists. Just by participating, there are a lot of ways to use the EIA process, and just by participating in the administrative process, an activist can help the climate, even if you're not a lawyer, even if you're not going to want to do litigation. There are often good opportunities for litigation, though, if you can do it, if you can afford it. And these lawsuits are relatively inexpensive compared to the big ones. Their costs are within the reach of citizens groups. So the Climate Litigation Toolkit from Cool World Institute, the idea is a menu of potential legal claims that smaller non-government organizations, NGOs is the international term for nonprofits, but it's the smaller types of lawsuits that NGOs that aren't super well funded can afford. The big lawsuits that Michael Gerard will talk about, Michael Gerard and Nicholas de Satelier today, like Juliana and Urgenda, they get big media attention, but they're really expensive. My estimate is that these lawsuits cost $1 million each. The smaller lawsuits can be brought by NGOs and are relatively inexpensive compared to this. And they can be used to fight climate change, either by providing a remedy, which is what judges give you at the end of a lawsuit if you win. They give you some sort of order, something that helps the environment if you win. But the remedy is one possibility, but even if you lose the case and don't get your remedy, the lawsuit can serve to publicize the issues or can force bad actors to spend money on litigation. And these, a lot of these theories that are included in the Climate Litigation Toolkit can be used in multiple countries around the world. So we've started a documentation of this on our website at Cool World Institute, and would be very glad to have lawyers help out with it. Okay, on to environmental impact assessments. Here's an overview. They're called different things in different places, and we'll get to that, what they're called in the US. Meantime, but this EIA is a general international term. So you find it in the EU where there's an EIA directive from the EU to the member country saying you have to have an environmental impact assessment law in your country, and they pretty much do. But mostly outside the US, this is the name for this type of process. So the EIA is a written document that the project proponent or the agency approving the project must prepare, and it describes the project's environmental impacts. The purpose is to ensure that whoever approves the project, a public agency, will understand the environmental consequences of the project. Before these EIAs were required, which was in the US starting in the 60s, I believe, agencies would just approve projects without knowing the environmental consequences at all. So a state agency might build a bridge over a river, and somebody on the board approving the project would say, well, does this do anything to the environment? And well, we don't know. We don't know whether it's in the middle of wildlife crossings or the supports going down into the river water are going to hurt fish or anything like that. So they would be in the dark when they approved the project about what's it going to do to the environment. And so with the advent of these EIA laws, starting with NEPA in the US, the idea was, okay, you can still go ahead and approve it, even if it has terrible environmental impacts, but at least you're going to have to know what they are. And the remedy, of course, if you approve something that's bad enough that really hurts the environment and gets everybody mad because of that, and it's not worth it, the project is not worth all the adverse environmental consequences, the remedy for that is at the ballot box. It's like you approve one of those things, and we know you knew about those environmental consequences. Maybe you'll get voted out at the next election. So most of the time, that's all that's required is a documentation of the environmental impacts. In some jurisdictions, more things are required than that. In parts of the US, for example, mitigation measures, in other words, measures to reduce impacts on the environment, must be adopted if they're feasible for significant impact. And alternatives, like different ways you could structure the project to avoid environmental impacts, those must be included, and in some places they must be adopted if they're feasible. The public pretty much always has the right to participate in the EIA process by reviewing and commenting on the EIA. And this is an important thing that activists can do even without help from lawyers. Just look at the document and see what's wrong with it. If there are analyses that are deficient, then raise those as comments, and maybe they'll get corrected, and maybe that'll help change the project for the better. And then NGOs, nonprofits, often have standing to sue for violations of the EIA law. This varies again from jurisdiction to jurisdiction, and we'll kind of talk about that in a little bit. So here's a generalized version of the EIA process. What happens as an EIA is prepared. First off, there's a screening, which asks the question, is this project subject to the EIA requirement? So things that obviously have no impact on the environment. You adopt a new ordinance requiring people to pay in cash at the city clerk's office instead of paying by credit card or something like that. I mean, there are things like that that just have no impact on the environment. So they get screened out. In some cases, there are smaller versions for things that do have impacts on the environment. They're smaller, less complicated processes than a full EIA. In California, there's something called a negative declaration, which is a declaration that the project has no significant environmental impacts that can be used, but it requires analysis. If you do that, it's like a mini EIR that goes through the different impacts and says why those impacts are not significant. So sometimes that's part of screening, is to decide which form of EIA to use. Scoping decides which environmental impacts should be analyzed. So you don't always analyze all of them all of the time. If you have a project that's in the middle of the city, on a little lot in Manhattan or something, there's no point in going into, are there going to be endangered species present on the site? There are a lot of things that are just not applicable to most projects. So in scoping, you figure out which impacts might be significant, and you analyze those in the document, which is the next part, this impact analysis drafting the EIA. That is preparing the document that describes and ideally quantifies in some detail all the various types of environmental impacts the project will have. So that's prepared by whoever's doing the project or the agency that's approving the project. It's often prepared by consultants that are hired by one of those people. And then once that is out, there's usually a public comment opportunity. The public can read this thing and send in comments on it, and often people who prepared the EIA have to respond. If litigation is contemplated, it's important to get all the issues into the record during this comment process. We'll see there's exhaustion of administrative remedies, which means you can't bring up anything in litigation unless you've exhausted with respect to it. That is, you've told the agency, hey, you're doing this thing wrong. So when it comes time to sue, you say again, hey, you did it wrong, but we told you before, and you had an opportunity to fix it. And then at the end, after the public comment is over, sometimes a final version incorporating the comments or responses to comments is adopted, and the project gets approved. Usually the EIA is approved at the same time, and often they both happen at a public hearing. So after that, one can sue. If you'll see, it's not everybody who can always sue, but that there's often a litigation opportunity at that point, which is sometimes a very powerful thing. So on the litigation, if you go ahead to litigation, there's an issue of standing, and that really says who can sue for particular injuries, really. For cases in the federal court in the US, there's the standing requirement is important. The NGO must show that it or its members have been injured by the approval being challenged. And this requires a certain care in getting your plaintiffs together and getting the right types. So people who use a particular area might be affected directly by a project that affects that area, for example. In civil law countries, this standing is controlled by statute. For example, in France, the Environment Code gives standing to NGOs who have in their purpose protection of the environment. So they're, you know, it's not all NGOs who can sue, and it might not be all individuals who can sue either over these things. In California, standing is just seldom an issue under the EIA law, which is known as CEQA, the California Environmental Quality Act. Another important aspect of litigation is exhaustion of administrative remedies. As I told you before, the NGO or somebody must have commented on the project. Well, the NGO or its members must have commented on the project and opposed the project during the administrative process, but also somebody must have put in the grounds for the lawsuit. And in other words, if you're going to sue saying you should have analyzed the water quality impacts of the project more, you have to have said that in the comments during the administrative process, or your lawsuit's going to get thrown out. And if there are appeals, like sometimes these determinations by a body, like here in Los Angeles, a determination by the City Planning Commission might well be appealable to the City Council. And if that appeal is available, in order to litigate later, you have to take that appeal. Another set of litigation issues. In the US, filing an EIA lawsuit does not stay the project, but plaintiffs can seek a preliminary injunction to stop it until a court case decides the case. These are difficult to get for a variety of reasons I don't have time to go into. In most cases here, the developer won't proceed with the project while the litigation is pending, because if they lose the litigation, they might be ordered to change the project, or their approvals could get set aside. Essentially, they might be forced to tear it down. So they often don't take the risk. Settlement is an important possibility for EIA litigation. The filing of the case gives a plaintiff NGO a lot of leverage to obtain environmental advantages. A lot of times, when it's a private project approved by the state or a city or county, the developer cannot get financing for the project a lot of times while the litigation is pending. So this effectively acts as a stay on it, but it also gives the NGO, after the lawsuit is filed, a pretty good set of poker chips to use to try to force the developer to improve the project. The most common remedy in a lawsuit like this, if the NGO sues and wins, usually you're arguing that the EIA is inadequate. They didn't come up to the standards that are required, and the court will order the EIA set aside and all the project approvals set aside, all the project approvals that were based on the EIA. And in the US, prevailing plaintiffs can usually recover attorney's fees from the project applicant, but not vice versa. So that's really an important incentive. It means in the US, if you sue and you win, there's a good chance you don't always get these fees, but often one does, and plaintiffs can end up with a lawsuit costing nothing if they win and recover the fees. It doesn't work the other way, though. If the developer wins the lawsuit, they don't get to recover their fees from the plaintiff. So here's an example EIA case that we were involved in. Newhall Ranch in northern LA County is probably the largest housing project ever approved in California and maybe in the US. It's a really bad project. It's 21,000 and change new houses to be built in the floodplain of the Santa Clara River on 12,000 acres they own up there. The EIRs for the first two phases contained an argument that the project's GHG emissions were not significant under the California Environmental Quality Act, the California EIA statute. So no mitigation was required. And I won't go into what this argument was. It was sort of convoluted and complicated, but they won on this argument. You know, that's what we sued them over, that and a few other things. But we lost on that argument in the trial court. We lost on that argument in the California Court of Appeal. But one of the three cases, it was not the one that I was a lawyer on. There were our two. We were lawyers on the landmark and mission phases of the project, but there was another case involving the fish and wildlife approvals for the project. And that case went to the California Supreme Court, where they invalidated the portion of the environmental impact assessment having to do with the GHG emissions. So what happened was the court ordered the EIA, I'm on the wrong case here. The court ordered the EIAs, I don't know why this keeps going, set aside. And Newhall, instead of coming back with a new argument that the GHG emissions were not significant, they decided to change the project so it would be net zero. And they put solar panels on houses, electric vehicle charging stations, electric buses. So this is a pretty important result we got from this case, which ended up being pretty much free to our clients because Newhall ended up paying our attorney's fees. So we improved greatly this project in terms of its GHG emissions by doing this litigation under the EIA case. So I'm going to go through pretty quickly a couple of foreign cases. This Lamu power plant in Kenya was approved by the government, and then Save Lamu, a local nonprofit, sued under the Environmental and Social Impact Assessment Act, and won. The court found that there'd been inadequate public participation and that some of the mitigation measures were inadequate. The public participation part is important. You know, a lot of times when we're doing these lawsuits, it's a fight about the developers or the agency's science versus our science. You know, who's right about what effect this will have on some plant or animal or some other impact or traffic. You know, they do a study and we do a study, and it's like dueling studies and we lose. One thing that really wins whenever you have it is procedural problems. You know, when they don't follow the right procedure, the court picks up on that immediately. And this inadequate public participation in the Lamu power plant case is a good example of that, where it's not really about the impact per se. It's like the state did not follow the right procedures when they approved the project, so it gets set aside. So that's something lawyers can help you figure out when that happens. Another example was sort of a reverse version of this. In Australia, the government Minister of Planning denied a permit to construct an open coal mine, and the mine sued the government. You know, this is reverse, you know, of what we normally do. But of course that happens a lot. Most of the time on the projects we're at least working on, the government never says no, they always say yes. But when they occasionally say no, often they get sued by the applicant. So this is one of those cases where the coal mining company sued, and under the Australian version of the EIA Act, the court could consider more, and this is something to look at. In these cases, the court can consider not just the quality of the environmental impact assessment, but also public interest for the project. They can consider the merits of the actual project, and the court upheld the Minister of Planning's denial of this project based primarily on the public interest. They decided there was a lot of greenhouse gas international things like the Paris Accord and such in this decision, where they decided that the negative impacts of the project were kind of outweighed the positive impacts, and they upheld the court turning down this EIA. I've got a question about GHGs. When I say that, we'll probably hear that a lot today. GHGs are greenhouse gases, and of course, greenhouse gases are what makes climate change. So greenhouse gas impacts are pretty important. Okay, so what happens after the litigation? Often the delay caused, this is part of why the environmental impact assessment statutes are kind of Swiss Army knives for the environment. There's a lot of different ways they can be used. What we've seen is a lot of times for especially private projects, a lawsuit under the EIA laws will delay the project. They won't want to go ahead or be able to go ahead until the litigation is resolved. And it often takes maybe 3 years in California because most of these cases are appealed. So 3 years later, they can't do the project is what happens a lot of the time, because the whole project has fallen apart. The people who are going to do it just aren't there anymore. If the petitioner wins, then and the opponent wants to go on, and this is what happened in Newhall, then the court usually orders the project approvals and the environmental impact assessments set aside, and the agency and or the applicant, the developer, whoever's trying to do the project, they have to go back and redo those things, or at least redo the parts of those things that got set aside by the court. And what happened in Newhall is once they went to net zero, they filed a new environmental impact assessment, just revising a couple parts of the EIR. And we sued again over that. And we said, it's not really net zero, it's not good enough. And the court disagreed with us, and we kind of lost on that in both the trial court and on appeal, and that litigation is almost over. But if you have a really serious proponent of a project, that's what's eventually going to happen in these EIA lawsuits. You will keep suing until the court says, no, no, everything's fine, and then you're kind of done. But as I said before, sometimes the parties will settle in these cases, and that settlement can be provide significant environmental benefits. So that's the end of my presentation. Let me see if I have any questions that I can answer. There's one about the Jordan Cove pipeline case, a federal approval, even though the state had stopped the permitting. I don't know the answer to that. It's, when you get into these federal state approval things, sometimes like in the Newhall case, there was a joint, here, let me stop my screen share. There was a joint EIS, EIR, which included both the sort of the federal part and the state part. And that gets a little complicated. So I don't have the good answer for that question. But my presentation is over, and it's time for me to introduce our next presenter. So thank you all for listening to my presentations on EIAs.